Thank you. You may be seated. All right, we've got one case on our agenda this afternoon, case number 23-0221, Jennifer Murray and Gregory Joy versus Napier and Company of Pensacola et al. Counsel for appellants?
Yes, Your Honor. Thank you, Chief Judge. And may I please reserve 3 minutes of my time for rebuttal?
You may, yes.
Thank you, Your Honor. And good afternoon. May it please this court, my name is Bailey Howard, and I represent the appellant homeowners, Dr. Jennifer Murray and Dr. Gregory Joy. Your Honors, when a trial court imposes discovery sanctions, the decision to do so has to be grounded in the evidence and guided by the law. And in this case, neither of those criteria were satisfied. The trial court abused its discretion first by effectively dismissing the homeowner's counterclaims with prejudice as a sanction, and then again by literally dismissing them with prejudice as a sanction, and then further abused its discretion by holding that an alternative basis of spoliation justified the dismissal. And in fact, in each of those instances, Your Honors, the evidence and the law pointed in the opposite direction. The trial court abused its discretion on each of those points, and this court should reverse and remand for further proceedings in light of that. As to the first point, Your Honors, the trial court abused its discretion by effectively dismissing the homeowner's counterclaims after their expert witnesses had technical issues and technical difficulties that, one, were not within the homeowner's control and arguably not even within the homeowner's awareness, as the trial court found, and that happened without their involvement, that resulted in late disclosures of certain evidence. And it's important.
Let's explore that a little bit. I mean, I think one of the things that really stood out to me as I was reading the briefs and the record here were the statistics. In terms of the 2020 order compelling record production, your client had produced 11,118 records, but there were 67,000 records missing, so 86% of the total production not produced. When it came to the photographs for your expert witness, there were 182 produced, but 630 total. So 72% were not produced. So this isn't finding a box of documents that someone, forgot to. This is not just the majority. This is the vast majority of documents and photographs that were not produced to the defendants.
Yes, Your Honor, that's correct. And I don't want to minimize the magnitude of that at all. That's certainly a large volume of documents, but as the record also reflects, most of the things that were not disclosed were either duplicates or were things of little substantive value, like red receipts or calendar entries, not all of them.
Or maybe, testing on some of the materials. I mean, there were photographs on, I think it was moisture readings. One was produced, and 20 plus weren't produced? I mean, these aren't insignificant omissions. And again, I can tell you 15 years on the bench, I've never seen this amount of discovery withheld in a case. So again, the trial court found it was more than inadvertent. And you're saying that there's no evidence to support that, but the statistics seem pretty powerful on that.
The statistics are indeed powerful, Your Honor. But consider also what the trial court did and what the trial court's reasoning was. So at the time the trial court made its decision to strike all of the evidence the experts had ever produced, including the ones that were properly disclosed, because the trial court struck those as well after those late disclosures. In the ruling that concerned the privilege log in the order that came before the December 2021 ruling, the trial court had previously ordered that nothing that was produced after February 19th, 2021 would be admissible without good cause being shown. But everything that had been produced to that point, everything that had been properly produced, was admissible and free to use.
Fair enough. Again, we're talking about, in the case of the documents, 14% had been admitted, 28% of the photographs, but then you magnify the amount of discovery and evidence that the defendants now have to use to defend themselves in this civil action. And so you're asking us to find that no reasonable judge would have taken the action that Judge Shackelford would have taken, and help me understand your argument on these facts.
Well, Your Honor, the basis for the argument is that there was no reason to strike the things that were properly disclosed. No prejudice could flow from those proper disclosures. Now, the things that had not been disclosed to that point, it was certainly reasonable to strike those as Judge Shackelford originally did. Her original ruling was that the things that had not been disclosed by February of 2021, but that existed and should have been disclosed, which would include all of those documents that Your Honor just referred to that had not been disclosed, that those would be off the table. Those would not be admissible, that nobody could use them. But Judge Shackelford went further than that in this case, and that was the first abuse of discretion. What the trial court did here was not exclude only the evidence that had not been properly disclosed. The trial court punitively excluded all the evidence that had been properly disclosed, even after finding that there was a reasonable explanation that the homeowners had not been involved. And those two factors, despite the statistics that Your Honor recited, are really quite dispositive of that question, because there's no reason to strike what was properly disclosed. No prejudice can flow from a proper disclosure like that. And if the trial court had sat on the situation that it had already contemplated could occur and said, yep, my prior ruling controls here, these documents that are late disclosed are not admissible absent good cause shown, and
I think you're arguing something on what reasonable minds can differ. Did the trial court preclude the plaintiffs at that point from bringing on a new expert?
No, Your Honor.
Right, so you could have retained another expert, right?
Yes, Your Honor, but almost effectively to what end? That expert wouldn't be able to conduct any further destructive testing on the home, although Napier and the contractor's experts would have been allowed to conduct further destructive testing on the home. The new expert also was not allowed to rely on any of the former experts' materials, photographs, opinions, even the ones that had been properly disclosed.
Would the new expert have been able to look at the testing done by the defendants?
He would have, Your Honor, yes.
Okay, thank you.
But there would be no reason for the defendants to do any further testing because they didn't have a burden to prove anything about the condition of the house. Napier's claims were a breach of contract and an unjust enrichment claim, not construction defect claims. And Napier's claims against the contractors were all pass-through claims based on the homeowner's claims. And so just from an analysis of the burden of proof, while it's true that if the defendants, if the appellees had conducted further testing, that should have been produced and the replacement experts would have been able to rely on that testing, the homeowners experts wouldn't have been able to control that testing, and there's no particular reason for the appellees to do that testing in the first place. And this is illustrated by the fact that there was a roof inspection that was scheduled for about a month after the second deposition of Mr. Alford, and the appellees canceled that roofing inspection, which would have shown the condition of the roof. There was still several months of discovery, several months of expert discovery to be done at that point. And remember also at this point, Lowry still had not filed an answer. And so there could be no prejudice to its defense from having to adjust at that point because they hadn't put a defense up in the first place. The appellees, instead of seeking that further testing, canceled that inspection, did not conduct any further testing. And so what the trial court's order did is functionally, it set up the homeowners in a condition where they were effectively doomed to fail. They were at the mercy of the other parties to conduct investigation that their experts would have to rely upon to prove their claims, which the other parties would have no particular strategic reason to do. And they weren't allowed to conduct any investigation themselves, and they couldn't rely on any evidence even that had already been properly disclosed and from which no prejudice could flow. And so applying the Kozel and Binger analysis to this, we have an incident that was outside the homeowner's control and that was caused by, in the one instance, a disorganization within the expert witness's office, and in the second, by a technical error within a program that nobody anticipated and that nobody involved in this case programmed and therefore was unable to control. And
Which part of the Binger test do you think wasn't covered in the judge's order?
That would be the ability to cure the prejudice resulting from the late disclosures, Your Honor. That's something that Binger specifies and focuses the court's attention on that Kozel does not include. That's the extra work that Binger does, and that's the benefit that would be gained by requiring a trial court to consider Binger as well as Kozel when it strikes an expert witness and effectively dismisses a case, as it did in these circumstances. When a case is going to have to be proven by expert evidence to this dispositive extent that this would be, because no lay witness is going to be able to testify as to the expert matters that are going to be dispositive of the proof in this case, it makes sense to then incorporate the Binger standard into the Kozel standard for dismissals. And in this case, Your Honor, the consideration of that additional factor of whether the prejudice could have been cured would have prevented the trial court from taking these unnecessary punitive steps in that first batch of sanctions, because it was obvious that there was a cure that was available. The cure was to provide more information, provide opportunities for discovery, to exclude the evidence that was not properly disclosed, as the trial court had already done. There was no need for the trial court to take additional action, except perhaps to shift attorney's fees to the extent that some time was truly and completely wasted as a result of those disclosures. To the extent the appellee's experts had relied and spent time and engaged fees that could not be turned towards an adjusted case during discovery, then maybe that would be wasteful. But this court should be careful how far it goes down that road, because of course discovery is an evolving process. Nobody goes into discovery knowing the pure fact of the platonic form of the truth in their case. The case develops during discovery. We learn things. That's the point of these on-site investigations in these construction cases, and the point of this destructive testing is that we don't know what we're going to find, so we have to go look.
And so it seems that the case had been pending for about 4 years when this discovery of this 67,000 new pages and 630 more photographs. I mean, this isn't that it had been going on for 11 months and people trying to work out what are the issues. I mean, this is pretty mature, a pretty mature case at this point. And when it sounds like you're minimizing a little bit on the defendants' preparation of their defenses. There's no doubt that there was expense in attorney's fees and expert witnesses, and the court herself explained how much time she had spent. Right? Can you quantify the amount of time she spent on privilege logs and dealing with motions to compel?
I cannot, Your Honor. And I just don't have that information available to me, and I don't want to minimize that at all.
It's in the record, so I think we know it. Isn't one of our concerns a proper administration of justice when we're looking at all of these factors as well, and it's one of the concerns for the trial court?
Yes, Your Honor, it certainly is. And I'm sorry, I understood your question to mean, could I put a number on it? Mm-hmm. And I could put an amount of time in months, but as far as the number of hours Judge Shackelford spent, I couldn't say that with certainty. But it certainly caused Judge Shackelford to expend a significant amount of time, but consider what she had to spend a significant amount of time on and why. There's, on the one hand, the reviewing the privilege claims that the homeowners made, and the homeowners probably should have made those claims earlier based on earlier disclosures when those things should have been preserved. And again, Your Honor, I don't want to minimize that at all. That was a significant, substantial failure, and the trial court needed to deal with it somehow. But the other thing that impacted the course of justice here, that substantially impacted the trial court's calendar, was the appellee's habit of filing emergency motions for things that were not emergencies. I have difficulty imagining a situation in which there could be an emergency need for attorney's fees as a sanction. An emergency, as this court has admonished in its triple deconstruction case earlier this year, is a serious matter. It's a button that parties should hesitate to press.
Oh, that's within the sphere of the trial court controlling its case, controlling its docket, and administering its own court, right? Kozel, Binger, they both talk about this is an area of substantial flexibility for the trial courts. There are certain things the trial courts need to do, but as far as how the trial court handled it, whether it could have gone a little bit left or right or what have you, there's a lot of discretion there, correct?
Certainly there is, Your Honor. The trial court has ample discretion. But a trial court, when confronted with an emergency motion, its typical reaction is not to sit back and calmly say, is this really an emergency? Do I really need to consider this right now? When it's denominated as an emergency, the trial court's reaction is typically to treat it as if it is an emergency. The parties bear some responsibility for properly designating something as an emergency in the first place.
Can you talk a little bit about the relationship of the second and third issues that you've raised on appeal to what I think you've mostly spent your time so far talking about the first issue. Can you talk about the removal of the roof and how those ultimate decisions of the court may relate to the decisions that were made earlier?
Yes, Your Honor, I can. So the relationship between those begins with the fact that the trial court based its second sanction on the prior sanction that we've spent this first portion of this argument discussing. And that's something that Kozel expressly incorporates. Has the attorney been sanctioned before? And in this case, that relationship is a significant intertwinement. I think the trial court's orders reflect that a substantial reason why it ordered further sanctions was because the trial court, in its view, had sort of given the appellants their first bite at the apple and put them on notice.
So let me put maybe a more point to my question. So You seem to acknowledge that some sanction was appropriate originally. You know, maybe exactly what that was, maybe there's some argument about. But ultimately, the trial court makes subsequent decisions that are based on the fact that there had been sanctions imposed previously. Ultimately, whether the sort of left or right guardrails of that first decision, do they really affect the decision that the court ultimately made with regard to issues 2 and 3?
They do affect it, Your Honor, but I don't think that they are independently sufficient to support the second sanction. I'm not sure that I'm understanding your question fully, and I apologize if I'm not. But the second set of sanctions, which was to outright dismiss the counterclaims on the alternative basis of Kozel and spoliation, it took account of the fact that there had been a prior sanction, but and it said, well, this. And the trial court said that its secondary sanctions, or its second-in-time sanctions, were based in part on the fact that it had already sanctioned the homeowners. And so if this court finds that the first set of sanctions was improper and was an abuse of discretion, it should hold that the second set of sanctions was also an abuse of discretion because it was based in part on that first set. But then taking the second set of sanctions on their own face value, there is a significant failure in the evidence there. There's no showing in the record that the homeowners intentionally and willfully caused the removal of their roof. What the record reflects is that the roofing contractors misled them and said that, yep, we have Lowry's permission, Howell knows about this, it's been coordinated.
It was within their sphere of control to figure that out, wasn't it? They knew the night before, and the roofers were there. They could have told them to go home until they get it straight themselves.
Well, Your Honor, they did.
The burden is on them, it would seem.
Well, Your Honor, I guess the response to that would be that the burden was on them to do what exactly? The burden on them to tell the roofers to go away, which they did do. But if the roofers then said, no, we've got clearance, and then start putting up ladders and climb up the roof, what then was Dr. Joy supposed to do? Was he supposed to physically interpose himself? I mean, what else could Dr. Joy have done other than tell the roofers to go away and then call his counsel and say, hey, the roofers are here and working, did you clear this? Which is what his testimony says that he did. But even if we remove his testimony from the equation, there's no reason to, and if we say that he's not credible at all, and I'm verging into my rebuttal time here, so I'll try and be brief, there's no reason for the homeowners to do this. It only prejudices them. It destroys the evidence that's critical to them to prove their case and puts the appellees in a position to say on summary judgment they cannot produce the facts to prove their case, and so we are entitled to summary judgment. And unless the court has any more questions for me right now, I'll reserve the remainder of my time for rebuttal. Thank you, Your Honors.
Good afternoon. May it please the court. My name is Chris Ritchie, counsel for Napier. I'm joined at the table by Sarah Shaleen, who represents Lowry Roofing, which is a separate appellee in this case. I will be making all of our arguments today on behalf of the appellees. The question here, I think Judge Rowe hit on it from our perspective, is that the question here isn't whether a different judge might have come to different decisions here. The question is whether Judge Shackelford abused her discretion. And there are a lot of case lines when you're dealing with Kozel and you're dealing with Binger and you're dealing with some of these other cases. Nob Hill was cited by the appellant. There are different lines of cases depending upon who's responsible for the sanctionable conduct and what is the procedural posture of the case. I would submit that this case involved a trifecta, kind of a perfect storm of sanctions multiple times, and that we don't need to get down necessarily in the weeds of figuring out, what is the exact line of cases that would be, perfect here. I mean, I think the court did go through the analysis at each step. She made very thoughtful findings and was very familiar with the record. And
Well, let's start with the first sanction of striking the one particular expert or the experts for the appellant. Why wasn't that an abuse of discretion? And, the appellant argues that the documents associated with the expert's testimony that had been duly admitted should not have been, stricken from the record and found inadmissible. That this expert should have been allowed to testify. It was too severe a sanction in light of, I guess, some computer errors and some other inadvertent types of withholding of documents. Can you address those arguments that were made to this court?
Yes, Judge Rowe, I will. I will just note really quick that our position is that if the court's decision dismissing the entire case, the counterclaims, if that was proper, we don't really need to get to the first order, but I'm happy to address your question. I think as you noted, the percentage of documents that were not properly disclosed was huge. So this isn't a case where we're talking about a small batch that could have been easily fixed. And in that respect, I don't think it was an abuse of discretion to say years into the case, the judge is just going to find that there is severe prejudice based upon this. And there had been, as we laid out in our brief, there had been 2 prior sanctions orders before we even get to the order where Judge Shackelford decided to strike the 2 experts. She did not prohibit them from naming additional experts. She did not prohibit them from doing additional testing. And I think even the appellant argues at some point that, well, there's really no prejudice even after the roof was destroyed because the appellees still had photographs taken by other people. They basically could have recreated the situation. And I feel like they're trying to have it both ways a little bit there. But not only the strategy of the parties, which is only one part of it, the number and the percentage of documents which you detailed which were withheld are significant and beyond anything I've read in any of the cases cited by any of the parties. And then we also have the issue that sanctions are meant to be punitive at some point. And this had occurred multiple times with the experts. They could have gotten additional experts. They could have been present for additional testing conducted by other experts. And Judge Shackelford even considered, when she entered the order striking the experts, at that point, she considered the Cozell factors. The appellant actually said that in their motion to reconsider said, well, you have to consider Cozell because this isn't effectively a dismissal. She said multiple times in these prior orders, well, I've done what I can. She had entered entitlement to sanctions. She had tried to do what she could to be the less severe sanction. By the time she's striking them, she has put everybody on notice of what was happening. She had tried to find a way to sanction them previously through the use of attorney's fees, and it did not work. And I think this was the 3rd order that we laid out in our brief where she finally strikes the experts. But again, she doesn't preclude them from getting additional experts. And that is not a full-on dismissal of the case, but she nonetheless did go through the Cozell factors. And those largely track Binger. And one difference I noticed, I think, looking at this again, was that from what I can tell, the Binger analysis, unlike Cozell, does not require a specific finding that the party itself had conducted the violation. Because in these earlier orders with the discovery problems, I think it's safe to say that the court found that there was a lack of communication between the expert and the attorneys, and arguably that's on them. At that point, I think the homeowners would at least have an argument, well, we were not involved in that. You can't put that on us. But the fact is the Binger analysis, to the extent that should have been what was used as opposed to Cozell, the Binger analysis does not have that same factor that I see in the Cozell case about the fact that the court's got to delineate, was the party itself responsible here? And I also note the Knob Creek case. I think it was a State Farm Knob Creek case that was cited. That had to do with an expert being stricken where there was not, as far as I could tell, an allegation that the client had done anything, the party itself. But the expert had served responses to unverified interrogatories, that served unverified interrogatories in response. There was a hurricane delay argued, and the expert eventually submits verified responses to interrogatories, which were identical to the prior responses that were given. The court in that case actually held that the court struck the experts due to the age of the case, in effect, is what the court says about that. And they find, even though the court found that the prejudice would have been curable by granting a continuance, the court still found, well, this case has been sitting around too long, and we're going to dismiss the case for that reason. In that case, the Nob Hill case again, that was the last remaining expert witness.
Well, let's talk a little bit more about Binger. Does Binger apply outside the context of undisclosed expert witnesses?
My understanding, Judge Rowe, is that Binger initially dealt with late disclosure of experts and then has been extended to cases involving experts changing their opinion before trial. And I want to make sure I answer your question, though.
So has the Florida Supreme Court extended Binger beyond the disclosure of experts as opposed to the striking of experts for discovery abuses or things like that?
Honestly, Judge Rowe, I don't know off the top of my head. I know that there are different lines of cases cited here, and some in the Binger line of cases about there has been an expansion somewhat, but I don't know the specific answer about the Florida Supreme Court in particular.
Okay.
I think what the appellant is arguing here is that the court should have analyzed Binger as part of its order striking the expert, but didn't do it. I think the analysis, most of the factors to me seem to be pretty closely related, and these lines of cases come down through different situations that exist. And what seems clear to me is this was the third order that had been entered by Judge Shackelford, and she is trying a way to figure out a less severe sanction. One of the reasons Cosell was raised was because there was an effort to get a dismissal of the counterclaim at that point. And Judge Shackelford...
Let's move forward to the ultimate dismissal with prejudice. Can you speak a little bit to why it's appropriate for the whole counterclaim to be dismissed rather than just the claims relating to the roof?
Yes, Your Honor. And I think Judge Shackelford addresses that here. She says on page 5193 of the record, this is in her order of dismissal, when she actually says, well, maybe applying this analysis to the landscaping, the alleged landscaping defects, Judge Shackelford said, well, maybe that's a stretch, but she had gone through months of analysis of these documents, hearings. She made a finding based upon her knowledge of the case and the facts of the case that even the landscaping defects that were alleged could have related to alleged issues with the roof, leaked roof, drainage, water issues of the property. That was something that she thought about. It was something that was debated and discussed at the hearing. It was addressed. The transcript is very long. It is something that Judge Shackelford considered. It was not something, for example, that she did it without, not only to have an evidentiary hearing, but that issue specifically was raised and was addressed in her order. And it's hard to go back now and summarize all of the issues, but there were I think the second amended counterclaim was the operative counterclaim. They did allege some water intrusion, additional damages to property. They alleged issues with the site work. And those are things that Judge Shackelford did address that I think that it is reasonable to believe that even the alleged landscaping defects could be affected by the inability of Napier, the inability of the third-party contractor defendants to determine what was wrong with the roof, what the defects were, when those began, and all that. So I do think that was considered. And again, our issue on the dismissal is that if the court upholds that, we don't have to get to the rejection or the striking of the experts. If the counterclaim was dismissed, we don't need to answer those questions. And I think the evidence, it was pretty clear. The evidentiary hearing that Judge Shackelford had was Dr. Joy was the only witness called, and she said she had concerns about this case even before he testified. That testimony to me, well, doesn't matter what I think. Judge Shackelford said she was concerned before he testified and came away with even greater concerns. What he testified was that he was aware of the contractors, other parties wanting to be present for any destructive testing. He had stopped the roofers before from tearing the roof off. He had the ability to do it. He could have done it. What came out when he was pressed in his testimony was that they had received, well, his wife, Dr. Murray, received a call the prior evening. The roofers are coming out tomorrow, and they're going to take the roof off. And when he's pressed, he says, he's asked all the questions I just said. He knows that other people need to be there. He knows it's not supposed to be destroyed. He is asked, well, how did counsel find out? Because you see in the timeline of events that counsel for the homeowners notified all the parties and said, hey, if you guys want to come over and look at the roof, come now, but most of it is already in the garbage. The work's being done. I think it was Judge Shackelford, but maybe one of the other parties asked Dr. Joy, how did your counsel even find out about it? He said, I don't know. Maybe my wife called. I tried to avoid her, which I think must, presumably he wasn't talking about his wife, but talking about the counsel, the trial counsel at the time, one of the trial counsel, that he just wasn't going to let them know what was going on. That is willful, it's deliberate. And we also later found out in that Mr. Howell, which was one of the experts that was stricken, was there when the roof was destroyed.
So let me bring you back to my question. So you have, when I look at the complaint, there's 29, as by my count, specific concerns that are raised, construction defect issues. Only one of them makes any mention of the roof. So there are all kinds of issues: brick issues, retaining wall issues, columns, window installations, all kinds of things that, at least on their face, don't look like they're related to the roof. So trying to bring you back to my question, acknowledging all of those things. Okay, sanction is appropriate. The roof is gone, and anything that is related to the roof would, perhaps be an appropriate sanction. Why is everything else, the 28 other items that they've raised, why must all of those claims be dismissed?
Yes, Judge, it's a good question. I was not, to be fair, I was not trial counsel, but I am aware that's one of the first things that kind of I was thinking about is how do these claims interrelate. I know the second amended counterclaim references other damage to the property, and again, I don't know if this is in the record. My experience is that when you have roof damage claims, they're often, and there's claims of additional damages, the roof claims are often critical to the rest of the case. And I thought I had read at some point that the homeowners had conceded, and maybe it's not in the briefs, maybe it was in a transcript, that the roof was a critical aspect of the case, and that's presumably why they never argued this is de minimis, don't worry about it.
So it's not clear to me in reading through the transcript where counsel are sort of latching on to the roof removal. On the landscaping side as well, maybe trucks were driving in and could have damaged some property. We don't know exactly, but we really would have wanted to look at the roof. Is there some evidence that needs to be presented before the court can dismiss the whole claim to show that the roof was actually related to these other claims?
Well, Judge, I think that the court did undergo an analysis, and whether that had to be part of the evidentiary hearing, I have not seen any case addressing that. In other words, one of the things that we argue in our brief is that for the court to get at that level of granularity would have likely required a mini trial where you would have had the experts, everyone could have gotten their own experts up there, without a jury, and you're putting the court in a position where it's got to be essentially making findings about very specific cause and effect relationship between
We have some precedents in play here. What is Kozel a claim-based case, or Kozel in its case is claim-based, or is it party-based? Is it the fact that a claim is bad, or is it the fact that this party that isn't complying with court orders and is?
Yes, Your Honor, and that maybe goes to my next point, which I think, and I want to answer your question. Kozel, as I understood it initially, seemed to kind of focus around attorney misconduct or attorney violations, and I think that is right. I don't think that necessarily goes to the merits of the claim, but it goes to the amount of prejudice to the parties, and that is something.
There's one defendant in the counterclaim, correct? I mean, he didn't sue the homeowners didn't sue the landscaper.
That's correct, Your Honor.
The homeowners
That's
just sued one party, and that was the GC.
Yes, Your Honor, that's true. But I don't know if I answered your question. I mean, I think Kozel kind of started with an analysis about the conduct of the counsel as opposed to the merits of the case. I think I mentioned the Nob Hill case where you were dealing with an expert. I didn't see any allegation in that case that the parties were involved. But even assuming Kozel doesn't apply, which I think there's an argument here that Judge Shackelford could have just dismissed the entire case on the basis of spoliation as a sanction, not only that it would create prejudice, and she acknowledged maybe the landscaping claim's a little bit tougher, but she did consider that and addressed it. But in the event here where you have the homeowners admitting, at least one of them, the only one who testified, admitting that he was trying to avoid his own attorney, that he had the power to stop the roof from being destroyed and failed to do it, that is as close, I think, if that doesn't suffice for spoliation case, I don't know what would. And whether we're going under Binger or Kozel or some combination of Binger and Kozel and other discovery sanctions, I believe the court clearly had discretion based upon that testimony from Dr. Joy evidenced a complete disregard for the case. They knew how important the roof was. They had been in hearings where their experts were stricken, and they just let it happen anyway. And so we would argue an alternative. Obviously, tipsy coachman is something that we've raised. Whether we're going under straight Kozel, Binger, spoliation, the court's inherent power, some combination of all those things, Judge Shackelford did not abuse her discretion, and we would therefore ask that this court affirm the trial court's rulings. I'll be finished unless you have any further questions.
Thank you.
Thank you.
Thank you, Your Honor. I'll pick up where my learned friend left off, which was with Chief Judge Osterhaus's question about Kozel and whether it's claim or party-based. Kozel is party-based, not claim-based, but in this case, the claims and the parties largely align because each subcontractor performed a discrete set of work and a discrete set of tasks. So the claim-based, party-based distinction is less relevant here than it could be in other cases, but just to clarify that for the court's convenience, that Kozel is a party-based look rather than a claim-based look. But what Kozel does require is evidence of prejudice to a particular party. And here, because of the way the case is structured, the way the facts occur in a construction case with subcontractors like this, that means prejudice as to particular elements of the work and showing that there was defect with particular elements of the work. And that means towards particular parties. And what was lacking here in the final hearing is evidence of prejudice to anyone except arguably Lowry and Napier, because of course if they needed to see the roof in its present condition and they were not able to do that after the shingles were removed, then that could have constituted some prejudice there if it was in fact prejudicial, because as we explained in the brief, they gained a summary judgment advantage from that rather than a disadvantage based on the burdens of proof.
Well,
But-
assuming the destruction of the roof was not materially prejudicial to the defense of particular defendants, in light of the progressive discipline and sanctioning that had gone on before the orders that are on appeal, why was it unreasonable for the judge at that point, after there had been a number of sanctions orders issued, and certainly destruction of the roof that was material to the claims of at least 2 defendants, why was that an unreasonable action on the part of the trial court?
Because, Your Honor, it would be sanctioning them for causing non-existent harm. If it didn't prejudice any of those other defendants, then there's no reason to impose any sanction as to anything that doesn't involve those defendants.
So the trial court should just look at in a silo as to each kind of harmful act done by the appellant. So when this happens, it should just, don't disclose 60,000 records, look at that. Don't disclose 600 photographs, and then now destroying the roof in the middle of litigation. We're just looking at that. We should disregard all of those other things that should happen.
No, Your Honor. And Chief Judge, I'm going to run out of time as I answer Judge Rowe's question. May I have leave to
Please.
run over?
You may.
Thank you. And so, Your Honor, the trial court shouldn't ignore those things, but the trial court should consider something that this court has never heard, which is an explanation of why the sanctions that were already in place weren't sufficient to redress the conduct that had already happened, why they weren't sufficient to bring the parties back to fairness and parity, which is what sanctions are for. Yes, they have a punitive element, but punishing a party for accidental things does not do the work of advancing the cause of justice and does not serve the interests that Kozel and Binger and the other cases that are before this court today were designed to serve. It shouldn't take a siloed or blinkered view, but it must follow the evidence and it must follow the law. Are there any further questions for the court?
Thank you, counsel.
Thank you, Your
And
Honors.
thank you both for your spirited arguments. Very good, very helpful to us. That's the only case on our docket, so we will adjourn.
All rise.